Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to our podcast, where we will take a high-level look at key issues arising from the government's white paper, Restoring Control over the Immigration System, which was published last month and potentially has wide-ranging impact on the immigration system in the UK. I'm Audrey Elliott. I'm head of the Global Mobility team at Evershed Sutherland. And for this podcast, I'm joined by my partner, Emily Hasted, and we're going to discuss the impact of the white paper, not just in terms of the content of the white paper in immigration terms, but also looking at it from an immigration and employment law lens.
Thanks, Audrey. What we'll be focusing on today are the employment law implications that may arise from the government's proposals if they're implemented in the current form. We will look at the white paper from an employment law lens and discuss what the risks might be and how we can start preparing for them now. Audrey, why are we concerned about this, and what are the key employment law risks for sponsors in terms of the changes proposed by the white paper?
Thanks, Emily. Well, let's start, because the white paper was, of course, nearly 80 pages long with appendices and supplements. So let's just start by reminding ourselves what the key issues were that were raised. So there were a number of proposals to the changes to the immigration system in the UK. Key changes for sponsors, and remembering it went a little wider than that, but the proposals are an increase to the skills threshold for skilled workers, an increase to the salary threshold for skilled workers, an increase in the English language requirement for skilled workers, and also an introduction for the first time of English language requirement for dependents. The proposal is also for a reduction in the length of a graduate visa, and probably the one that we've seen most discussion about in public spaces since the white paper is the suggestion that we will see the period of time that it takes for a skilled worker to qualify for settlement or indefinite leave to remain increase from 5 years to 10 years. Now, there's a lot of detail in all of those, Emily, and shall we just have a quick look at some of those in more detail, and then we'll explore what that means from an employment law perspective.
Yeah, thanks, Audrey. So if we turn to the increase in skill and salary threshold, what the government has proposed is a return to the graduate degree skill level called NQF level 6 for skilled worker visas. And what this would mean is a change to the occupational codes that are eligible for sponsorship. This would reverse the change made by the government back in 2020, and therefore less roles would be eligible for sponsorship going forward. Now, this approach would see the number of eligible occupations for sponsorship reduced by around 180 occupations, which is a pretty big reduction in those eligible for sponsorship. We do know that there will be transitional arrangements for those skilled workers currently sponsored under the lower skilled roles. So because currently you can have an RQF level 3 role eligible for sponsorship. Therefore, it's likely that we'll see individuals already sponsored before the changes being allowed to extend their visas, but we don't know exactly what those transitional provisions will look like yet.
Thanks, Emily. And similarly, I suppose from the salary perspective, we know we've got salary thresholds, both general salary thresholds and the thresholds for the relevant occupational code. And a bit like we saw in April 2024, the proposal is that the thresholds, both general and SOC code, will increase. Again, we don't have the information on that. But also there is a suggestion that there will be transitional arrangements. And what we have for the April 2024 change is that those that had skilled worker status before April 2024 have got lower thresholds to meet than those that entered the immigration category after 2024. And I'll just stick with just a brief comment on the English language requirements. So the suggestion is that the current state level that skilled workers must reach currently is B1, and that will go up to B2 levels, and again for settlement applications. And as I mentioned, for the first time ever, we will see an English language requirement for dependents. The suggestion is it will be pretty low at A1, which is the entry level, but even so, it's still something we've never seen before.
Thanks, Audrey. And as you mentioned before, one of the most controversial amendments we've seen is in relation to settlement. as the government have proposed a new contribution-based model, which will extend the time it takes to get settlement in the UK for a skilled worker from 5 to 10 years, with reductions for those who the government will decide contribute to the economy in specific occupations. We are waiting for further guidance on what this will mean in practice. And the white paper doesn't mention transitional provisions for current sponsored employees, which has caused much uncertainty and commentary at present. However, the government have confirmed it will consult on this and publish more details to be put in place before Parliament by the end of the year. So, Audrey, in terms of these proposed changes, what are the implications on this for sponsors and the employment relationship?
Well, I think, Emily, that sponsors need to look at these changes in relation to two cohorts of individuals. Firstly, their existing employees and what that means. And then secondly, for future sponsorship cases, just taking that first cohort initially. We've both mentioned about the increase to the skills and the salary thresholds, but we've also reflected on the fact that there are pretty likely to be transitional arrangements. And as I've mentioned, we saw that in April 2024. So to a certain extent, those already sponsors should be a little immune from that change. I think the biggest issue for employers will be the final bit, the bit about settlement. Because when an employer sponsors an individual, there are clearly costs around that. And finance colleagues will have budgeted for 5 years of sponsorship. If that suddenly becomes 10 years of sponsorship for individuals who are already in employment and tracking towards their 5-year anniversary, that's going to be quite a big difference in terms of costs that weren't anticipated by businesses when they took these employees on. And you've mentioned that there's earned settlement that could still deliver the 5-year route. But even so, it's not going to cover everybody and probably a lower number than the overall population. So at this stage, I think that sponsors need to be getting a real handle on who their skilled workers are. Obviously, that should be a given anyway as a sponsor part of sponsor obligations, but then looking at where those individuals are in their settlement journey, remembering that employment with a prior sponsor in skilled worker category will count towards the 5 years, and start to do some of the maths. Definitely give finance colleagues a head up that this will be a cost that's coming up. And then once you've got that data, when we know what the government is saying for sure about settlement, at least sponsors will be in a position to really think carefully about what that means for their existing cohort of employees. Would you add anything else to that, Emily?
Thanks, Rudy. I would just add that although we are expecting transitional rates for those already sponsored, it's really difficult to predict what that will look like yet. We're already seeing individual cases for those who were sponsored pre-4th of April 2024, when the last set of changes came in, who don't meet those increased transitional salary arrangements. And therefore, it's likely that we're going to see an increased risk of that moving forward if these proposals are implemented. Also, in relation to English language, if an individual cannot meet the requirement for extension or settlement, then we might see further cases of individuals ineligible for sponsorship going forward, which raises further employment law risks. This is a risk for sponsors because if the individual doesn't meet the requirements for sponsorship or switching immigration categories whilst in employment, then they'll be left without any right to work, which also may cause significant operational difficulties and pose employment law risks. What are those employment law risks? What would they look like, Audrey?
I think they fall into two categories. First one, clearly unfair dismissal. If an individual has been employed by the sponsor for 2 years, they will have unfair dismissal rights. So the employer will need to think about a fair process, going through that process with the individual to make sure that the ultimate dismissal is for a fair reason, which is going to be right to work and a fair process has been followed. But employers will also need to think about the objective justification in relation to any allegations of indirect race discrimination that may arise as part of that dismissal. They're really complicated, these dismissals, because you've got to think about employment law and immigration law at the same time. So I think it's really important that sponsors taking action on that basis seek early advice on their options and the process to be followed.
I agree with that, Audrey. And then also we need to look at the second bucket of employees, don't we, in terms of future employees. And I think in relation to that category, there are two issues. So firstly, recruitment and talent strategy. There are going to be roles that we can't use the skilled worker route for anymore. And how are we going to fill those talent gaps going forward? Secondly, for the roles that remain sponsorable, the cost is going to increase, both in terms of the Home Office fees and in terms of the anticipated period that we're sponsoring individuals for. If we have to sponsor for up to 10 years, as you say, Audrey, the cost is a considerable hike from the current 5-year period. And taking a decision not to offer a role based on costs alone raises an indirect discriminatory position that's going to be very difficult to objectively justify in an employment tribunal. We have the situation now in a way that the increase in thresholds will potentially increase significantly in that scenario of what we could sponsor but we prefer not to type scenario. And it therefore remains a very important thing for sponsors to consider and seek advice on going forward. Anything else that you would say to that, Audrey?
I think I'd just add, I agree with all of that, obviously. I'd just add the change to the graduate visa, because it's not one of the big ones with flashing lights. Just don't forget that the decrease of that's proposed from 2 years to 18 months. I think the main risk of that is the business that are taking in the graduates. They quite often, if they've been used to employing graduates, will expect the individuals to be with them for 2 years. And also that 2 years allows the individual to progress to a position where sponsorship might be possible. So we're possibly going to be in a place where a business would like to keep an individual, but they don't get there. So I think it's being upfront with the business. If they're taking on a graduate, what would need to be true in order to sponsor that individual at the end. So where are we? Well, at present, these are just proposals. We're likely to see them implemented at some point. I'm pretty sure about that, but there's a legislative process to go through. The changes will not be a change to primary legislation. There'll be a change to the immigration rules, but they still need to be laid before Parliament. And they must be given 21 days notice of that. There's lots of things to think about, particularly the settlement piece has got lots of discussion, as you said, in media. And I expect that if the cohort that are currently in the UK are caught by this, then there will be some form of litigation. I'm not saying whether that would be successful, but I can expect there will be some challenge because it is clearly a really emotive subject. But there's lots to come over the summer as we see the consultations coming through and then the statement of changes. With all that in mind, what should employers, or what can employers and sponsors be thinking about now, do you think, Emily, in terms of getting ready?
Yeah, Audrey, I would say that as a sponsor, an employer, I would be reassuring current employees that they're a valued member of the workforce, whilst explaining that it's not clear exactly how these changes will be implemented yet. So we can't give any specific promises to individuals, but reassure them that we're monitoring the changes. I would also be assessing which employees are currently employed in below degree level roles that are being sponsored, or may need to switch into sponsorship, so potentially those under graduate route and dependent visa holders, and consider whether we need to move them into switch to skilled worker now to sponsor them ahead of the changes. Also look at whether there are any other employees or roles in your recruitment pipeline below the degree level threshold that you would look to sponsor or extend now to avoid these changes. We also need to be thinking about future costs analysis, and as you mentioned, Audrey, what about the existing cohort and the extra expense, and alerting our finance teams or budgeting for it going forward, including factoring in the increases for the immigration skills charge increase that we know is going to be going up by 32% this year. And also, just finally, if we need to follow a right to work dismissal in the future, We just need to be wary of the potential discrimination and unfair dismissal risks that follow, and just remind to take early advice so that we can build this into our processes and put us in the best possible place when we're moving forward.
Thank you, Emily. So that's just a snapshot of some of the considerations we've thought about that could arise from the white paper and the eventual changes that come through. I hope you found it helpful. If you'd like to listen more, we've got our Immigration Roundup Live coming, and you'd be most welcome to join us on that for a discussion around these topics with our team and with colleagues in the similar situation as yourselves.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.